when the minister, the 16th of September, when the minister says this is urgent, and was there a board resolution backing your letter to do things slightly differently? So that's what we're addressing now. And Ms. Myeni, this is your opportunity to use your documents if you wish to answer those questions. And Ms. Myeni, may I say that you don't have to persuade the plaintiffs that Mr. Tambi and Ms. Myeni wanted to do this transaction differently. That is common cause. Excuse me, Ms. Kwinana and Dr. Tambi. We accept as common cause that Ms. Kwinana and Dr. Tambi were asking you to do this transaction differently after the board had resolved to do it the original way. So we don't have to waste time on that. We perfectly accept that. The question is what you did or didn't do.
My lady, thank you very much, Counsel. If I may, my lady, because I've got to sort of give context to what I did, as my lady did ask. The letter of the minister of the 30th of July, I think in the bundle it's 155A, approves the Section 54 application, but it does also it alludes to the application and the transaction not being comprehensive. What the minister highlights in his letter is the same thing that was worrying the board in terms of the comprehensiveness of the transaction, but also the in-principle agreement or approval was that we wanted to understand broadly from those that were negotiating the Airbus deal as to whether the deal negotiated can be compared so that we've got an understanding of whether the 12 years we are going to enter into an agreement with whoever that was the lessor, it is an agreement that considered all the dimensions of the deal. For now, what was being considered, in our view, was the PDPs that were going to be due and expected to be payable.
No, Ms. Myeni. The point about, it's common cause now. The point about the original swap transaction was that it meant that SAA no longer had to pay the PDPs. That is what was negotiated. If...
My lady.
No.
My lady, I've got to object. This witness starts off saying, I want to provide a context. And from my following of her answer, she hadn't got to the part where she was answering the question. Yes, ma'am.
Okay.
Lady, this cross-examination is taking an inordinate amount of time because the witness simply does not answer the questions. There's always context. Well, Ms. Myeni, we're going to be here all week and then we're going to have to call you back and you're going to have to come back to Pretoria because the answers are simply not forthcoming to the questions asked. Now, it is common cause, Ms. Myeni, that the point about the highlight of the original swap transaction that took months of negotiation in Toulouse were that SAA would no longer have to pay the PDPs. That is the point of the swap transaction. To say that that was still open is simply incorrect, and it's simply not what has become common cause, A, on the pleadings, and B, in evidence.
My lady, I am saying, and I know that the council wants me to answer in a specific way.
No, I don't. I just want you to answer my questions truthfully. And I reject you keeping saying that I want you to answer in a certain way.
No,
I just want you to answer the question. I'm asking the witness a simple question that requires a yes or no answer. The swap transaction originally negotiated meant that SAA would not have to pay the PDPs. Is that correct, yes or no?
It is correct.
It is correct, thank you.
My lady, that is one dimension of a 12-year agreement that we are supposed to enter into, one dimension that we are saying we have dealt with the aspect of the PDPs. That does not mean that my lady, the swap deal was approved. It's granted. But there were conditions, even on the board side. After the letter of the minister of the 30th of July, there were further steps that were taken, part of which, my lady, you wanted to find out. What is it?
No, that's not what my lady wanted to find out.
It did not seem to me that he had any problem with it, and that was fine. It would seem to me, on the evidence thus far before me, the only issue was the African raising non-community. Everyone said he's been dealt with later. I'm talking about the last approval, which was an
11th. No, it was on the 11th.
No, it was the 11th of July.
No, my lady. The 11th of September was the minister saying those aspects have been covered to my satisfaction. This is a final unconditional approval. That's on the 11th of September. There were many other letters later. But my understanding of this is that there is conditional approval. Well, some think it's conditional. And the minister asks for more information. He gets that information, and on the basis of that information, he gives a final approval on the 11th of September.
My lady.
It's on page 163, my lady, and we can see that it is final approval. His outstanding concerns had been met. We can't now use them to say the minister was still worried. My apologies, my lady.
That was 11 September, where it was saying
163.
placed into operating lease of Flight 833-300 aircraft, subject to the following information, and it is net present value analysis, which demonstrates that the equity arising from provide an infinite, comprehensive mitigation strategy to source additional aid when the aircraft required as per the need. And that seems to me that the only conditions.
And it's common cause on the pleadings, and it was admitted on Friday that this is final approval. So the question arose, why did Ms. Myeni not take steps? There was one condition precedent outstanding for this deal to be finalized, and that was that the board allow the CEO and the CFO to sign.
My lady, in the resolution signed, first, my lady, I would like to explain, because I've been granted permission to use these documents. May I then continue where I started? Because I'm not going to read the letter of the minister of the 30th of July. But my lady, subsequent to that letter, on the 7th of September, I write to the CFO. I ask questions. Board members had a number of questions that they had, which would then get a broader perspective and the comprehensiveness of the Airbus deal. The board wanted transparency in terms of who is this lessor that we are going to commit the company for the 12 years. The other aspect of the deal was that it did not consider other things, and the responses were not forthcoming. There were issues that were raised by Dr. Tambi. There were issues that were raised by Queen Anna. If I may, Queen Anna signed and said he's not going to agree to this deal because specific issues that were raised are not satisfactorily answered. And she says, I will not vote for this transaction as I do not believe this resolution. It's after the 11th of September when the minister, it's this one, my lady. It's got a handwriting on the second page. This is September 15, after the 11th, after the minister's final approval, as the council has alluded to. So she says, we received a specialist report and the chairperson raised specific issues, and until these are satisfactorily answered, I will not vote for this transaction, as I do not believe is in the best interest of South African Airways as it stands. It should be noted that I never voted for this transaction from the beginning, but I respect a majority decision with my views properly recorded. What are those views that she's talking about, my lady? There is a document that is before you, my lady, that is this one, paginated 404, which she, as the audit and risk chairperson, writes to me regarding the funding of an A320 swap transaction. She's also talking, my lady, on the risks aspects, because she was chairman of the risk audit and risk committee. She talks about the history that we have had, and we are trying to come out of the history where the aircraft that were sold were leased back to us, and that decision was wrong then in 2001, 2002. It's still wrong because it was still taking a lot of money to pay the lessors all those leasing fees. After that, my lady, after the decision to sell all the fleet, they decided to lease them back to SAA. But my lady, you will remember, that fleet was owned by SAA. So it had, the bad decision about it was that now SAA does not have a healthy balance sheet. So if we go out to the market, we must rely on the government guarantees because we've got nothing to show in our books. So we are averting the same thing where these A330s are still not going to be owned by us. So it appears then in the negotiation that is being put before us, there is no transparency. We don't know who this SPV is, but we hear it's Airbus, but Airbus has now, let me not use the abbreviation. There is a special purpose vehicle now that is being used. It's okay, granted that there is a special purpose vehicle, but let us understand who is this, how have they come into it, but have they considered all the questions raised by all board members, including the fleet strategy of the airline? May I then, with your permission, my lady, say, this is now Mrs. Quinana saying, there is a long history to this which is well understood. More recently, the board agreed to cancel the A320 aircraft acquisition and replace that with the acquisition of 5 A330 aircraft. The CFO with the then acting CEO and the head commercial negotiated a swap transaction which was placed before the board in a memorandum dated 30 March 2015. This was approved in principle subject to certain conditions. Thereafter, it was formulated into a Section 54 submission to the minister. Then followed certain clarifications from the minister, after which he approved the swap transaction. The CFO and the acting CEO then assigned the Airbus transaction agreement subject to board ratification. When this came before the board again, the board failed to ratify the agreement for a number of reasons. Then followed a meeting with Airbus, then further correspondence, and this ended with Sunday Times. I won't go into that. The exposure to Sunday Times, with your permission, my lady, can I omit that? I would now like to deal with this transaction itself. I place on record that I was never satisfied that this transaction was in the best interest of South African Airways, in the best interest of the company. On the 26th of September, Dr. Tambi and I met Airbus. The options we put to them was that there ought to be an option of a local leasing partner. We need to promote South African business opportunities, and we needed to consider alternatives to the currency risk. We were also not convinced that the Airbus-related party leasing company necessarily provided the cheapest option. At this point, it was clear to me that there were serious differences of opinion amongst the board. To resolve this, a proposal to appoint an advisor who could review the differences of opinion was circulated to the board on the 6th of October. The chairperson, Dr. Tambi, and I and Tony Dixon supported the appointment, although Tony's approval was conditional on a cost limitation. To my knowledge, the CFO did not provide a response. Subsequently, the CFO emailed Tony Dixon criticizing his support, which led to a further qualification from Tony. Although an informal proposal, the matter was supported by the majority of the board. On the 9th of October, a further memorandum was circulated to the board, proposing, firstly, the appointment of a named transactional advisor, the presentation to the board of South African Airways or South African entity wishing to propose alternative funding option, and thirdly, the board again met with Airbus urgently on the 10th of October. To my knowledge, formal responses supporting the contents of the memorandum were received by Dr. Tambi, myself, and the chair. It appears that Wolf, that is Mr. Mayor, might not have received this memorandum. It appears he subsequently did, as he attended the 10th October meeting, which was referred to in this memorandum. The 10th of October, on the 10th of October 2015, Dr. Tambi, Tony Dixon, and I met, Dr. Tambi, Wolf, Mayor, Tony, and I met Airbus. At that meeting, it was put to Airbus that we sought an option to either pay cash or find our own leasing partner. The Airbus representative did not consider the cash option, but in principle stated that the alternative leasing entity could be considered subject to an Airbus due diligence. Following the conclusion of that meeting, the chair arrived in time to meet with Mr. Hadi Akum. At this meeting, the various options were again discussed, culminating in an agreement of the following. Airbus would provide a written response to the proposal to either settle the full amount in cash or a local leasing partner. Neither option was proposed in principle by Airbus. Mr. Akum confirmed there would be no penalties, demands for immediate payment. It was confirmed that SAA required the aircraft as per the planned deliveries. On the 14th of October, Airbus responded, confirming that Airbus is willing to consider the outright purchase and also to the inclusion of a local alternative leasing company or partner. However, he also then added a rider that SAA would, notwithstanding such an agreement above, be required to pay an immediate US 17 million over time further PDPs for the new aircraft. The 17 million US dollars is the PDPs that is currently due and payable. The board has been provided the extension of 30 days to complete the various approvals. The funding, months ago, maybe this one might not be that relevant, but some months ago, Wolf invited potential funders to bid for consolidation of the debt, including replacement, renewal of retiring aircraft, funding the amount of 15 billion. This is also necessary for the government guarantee. You, Chair, have indicated that SAA ought to apply to government for a recapitalization grant. This recapitalization was included in the Cabinet-approved long-term turnaround strategy. If we are to proceed with renewal of funding and a consolidation, it appears to me that this is the time to push for the recapitalization. If we were to look at the recapitalization and a consolidation, of remaining debt and the funding of the A330s, then all these needs to be considered in conjunction with each other. So she recommended, Kwinana recommended, that we obtain written confirmation from Airbus that we can have these 30 days to propose. 2, a cash payment transaction. To propose 1, the cash payment transaction, and that there will be no penalties, i.e. no further PDPs for the original transaction, which will be required. The second recommendation was to approach National Treasury for government recapitalization with the proposal on how much is required and for what purpose, an urgent consideration. The third recommendation was an approach local private-public partnership parties for local funding of the A330s, an urgent consideration. In the event that a local funder is a leasing company, South African Airways prepares to enter into a lease agreement with the South African leasing company. The board receives a status report on the debt consolidation tender. I further propose an investigation into leaked Sunday Times documentation, whatever. Conclusion, Chair, these matters must be pursued with extreme urgency. May I recommend, should you agree, that this document be circulated to the entire board and an extraordinary board meeting be called to discuss the above proposal. My lady, in my email of the 7th, I raised questions. She also raises concerns. The last part that I want to delve into, my lady, is this the other one, which is more important as well, because these are issues that are raised by an expert in the aviation, that is Dr. Tambi, with 35 years of experience. He is saying, I am approving this resolution. However, I would like to list the following for the records and based on my over 35 years of professional international aviation experience. 1, in my professional opinion, this swap is not in in capital letters. This swap is not the best deal for SAA, notwithstanding what has been presented. Number 2, this entire swap was initiated and concluded by 3 individuals with very limited experience in this area, and one of them could possibly be conflicted.
Who are these 3 individuals?
Mr. Mayor, the acting CEO, and the GM commercial.
And this was raised in
This now he raises it in December.
In December?
Yes, he raises it in December.
For the swap transaction stop. It was approved in March.
In March, my legal
So
part.
only now in December, after the shareholder has been
This was
the shareholder is satisfied. Only now did this come to light.
my lady. There were continuous discussions. There were continuous. There is an email from Dr. Tambi of the 16th of September on this one that is very small font. This email, my lady, you have it. He says, Dear Ruth, thank you very much for Ruth is the company secretary. Thank you very much for your email. My decision regarding this particular resolution, having gone back to look at it, has not changed. Based on the emails regarding the same subject from the chair and the responses given, I still believe that SAA could get a better deal than what we have on the table.
Do we have any indication of what that big deal was, seeing that Airbus insisted on the immediate payment of that amount of money and the corresponding that.
My lady,
Anyway, that indicate what that better deal was.
my lady, all the board was looking into was, what are we comparing what has been putting on the table with? What?
Unfortunately, the board has since March.
My lady, there were a number of workshops, discussions, interactions.
Airbus was saying we want payment now. If you don't receive, this is your evidence there that SAA actually had the money to pay the PPPs that Airbus in the correspondence insisted on.
My lady, South African Airways belongs to government 100%. They are the 100% shareholders. They wouldn't allow South African Airways to fail, my leader, because
That's the answer.
This 100% shareholder, and I think Mr. Myeni referred to the fact that no guarantees will be given. And one of his instructions saw that the Airbus will be completed. On what authority did the three board members then proceed to refuse to sign the transaction? That is what I'm trying to understand.
my lady, I can't speak for them, but what this court is providing me is to state their side of issues, because at the end, with what Dr. Tambi is raising during now the tenure of Mr. Godan, he is raising the issues which he stood by, and he didn't sign and agree to the final resolution that was before him, and Queen Anna did not sign with the resolution that was before him, because they were saying, if then our duty is to say, because PDPs are due and payable, we're considering the cash, the cash flow options, we're only considering the financial aspects of this deal. We are then plunging into the company into a 12-year with no comparison.
The Minister of Finance supports this transaction. I just want to understand the authorities of a non-executive board. Is it your case that a non-executive board has the authority to override the decision by the 100% shareholder? I just want to understand how you saw the position of a non-executive board appointed by the shareholder, as far as I understand, an oversight function.
My lady, I would let them speak for themselves. If I speak for myself, when the minister, when the minister gave us an opportunity to bring various options before him. Excuse me, my leader, can I? Thank you, my lady. If I speak for myself, my lady, I did not have an authority to overrule or go against the minister's directive. But if I speak for the board members stated their views, tabled them, and why they decided. Hence, this final email from Dr. Tambi, where he says there was no objectivity, there was no transparency, and recognizing that South African Airways is the only major African client of Airbus.
But if the allegations are made of non-objectivity, non-transparency, where is the evidence of those actions? You can't just make allegations. Where was how difficult it was to negotiate this transaction. Mr. Sylvain was testified to that. Mr. DeSalle testified to that. And now an allegation is made about non-transparency. How? If from March the board knows about this transaction and they are informed about this, one must lay a basis for this non-transparency if one alleges it. Because this point is invalid.
My lady, it must also be noted that Airbus and SAA had a historic relationship. So I don't think the issue was more on the side of Airbus, but it was raised that this deal, my lady, as you correctly state, it was negotiated by 3 people, but they were not taking the rest of the EXCO into confidence, my lady. And Dr. Tambi states clearly that the 3 individuals with very limited experience, Wolf is a Wolf.
Mr. Bosch and Mr. Bolt may have very limited experience.
It's in black and white here, my leader. This is
in black and white. An allegation doesn't mean on what basis it says that these 3 people have limited experience.
my lady. He is saying this entire swap on number 2, my lady, of 404, of 409, it's bullet number 2. This entire swap was initiated and concluded by 3 individuals with very limited experience in this area. And one of them could possibly be conflicted. That could be his allegation and his understanding of whatever.
Mr. Tambi will come and testify and understand because you are just now saying what he said. Because all 3 of these individuals came and testified about their experience in the aviation industry and it wasn't pushed on cross-examination. And forgive me on the objective evidence before me, you can see that they are all experienced and they have proceeded to run successful airlines in America.
My lady, I am merely stating what Dr. Tambi is saying, but also, yes. Can I finish that sentence where he says 3 individuals, because the end of this part of the sentence says, most importantly, the entire EXCO was never privy to this swap transaction. Based on the above, the issue of transparency and objectivity could easily be raised. My lady, when
I would have expected the board then to approach the minister and say, and raise all these issues. Was that ever done by the non-executive board members to the minister?
I won't recall right now whether they sent their concerns to the minister, but they put their concerns in black and white. The other thing, the 4th bullet, he says, recognizing that SAA is the only major African client of Airbus, it is incomprehensible that in this entire swap, Airbus, in this entire swap, Airbus has treated SAA as though it were the seller rather than the buyer. How could this be? Most importantly, and an issue that has never been addressed, Airbus or the 3 SAA individuals that brokered this swap have never disclosed the leasing company that South African Airways will be paying the US dollars of the $644 million US to during the 12-year lease period. Finally, in 2004-2005 financial year, South African Airways lost 11 billion, and almost 10 billion was as a result of the hedging, of the dollar hedging. This could be a warning for the current swap. Finally, the exception of fuel cost, the other major cause of South African Airways' continuous loss, are the leasing costs, all of them in US dollars. But most importantly, they are poorly negotiated and managed. The in-house expertise is missing, and there is no dedicated team or division in South African Airways to handle leases and procurement. I honestly believe South African Airways can be successfully turned around, and this has been my main motivation and commitment for serving on the board, and I believe that I bring a wealth of experience unparalleled on the continent. It is against this background that I'm approving this swap, because I am approving this swap because I don't know that because it is apparent that it had become a major stumbling block in moving forward and focus on the work of turning the airline around. My lady, on the last aspect, after the final letter that approved this deal, we all went and approved the deal, whether people had dissenting views, but we owned the decision at the end. We all owned. After Minister Gordhan gave us an opportunity to present the options before him, and then he said, but here is the cutoff date. By this date, once you have submitted, I don't want to hear anything. I'll look at those options before me, and after that, I would like the approval, which of course did take place.
I want to talk about governance. Now, Ms. Myeni, yes or no, there was an unconditional board resolution on the 31st of March 2015 to approve the swap transaction. Can you just say yes or no? Let me read it to you.
My understanding is that there was an approval, yes, but there were some conditions.
Well, let's read it. Page 286G. Which volume is that? Volume 4, my lady. The board by round robin 2015/B27 as of 31 March resolved to approve the Airbus A320 A330 swap transaction to be achieved through amendment to the legacy A320 purchase transaction, whereby the last 10 A320-200 aircraft still to be delivered be cancelled and replaced by the 5 A330-300 wide-body aircraft to be leased directly from Airbus.
Council, sorry, I thought you said in March.
This is March, 31 March.
No, I'm reading the...
No,
I'm
my lady.
reading 22/12/2015.
No, my lady.
286G.
Yes. No, my lady, can I just explain that? The board resolved on 31 March. Now, this is the only copy we've managed to get out of SAA. The reason it's dated 22nd of December is because after Minister Gordhan and his officials spent half the night in the Treasury's office on the 21st of December, trying to get a ratification out of the board. This is what Ms. Kabuka said. There was never a fresh ratification. Ms. Kabuka sent the original ratification from 31st of March.
So 33rd of March was signed by the board only on the 22nd of November.
No.
But they were told
No. It was signed. This is a historic document. This was a document that start again. This is recording that there was such a resolution on the 31st. We have been unable to find the copy, but it records that is the date of the resolution. It is now redated the 22nd of the 12th because the Minister and the Treasury were demanding a ratification. Their evidence was that Ms. Myeni told them she couldn't contact Dr. Tambi. Ms. Kwinana was disagreeing. The other two acting executives had signed. So this is what was ultimately used to stop those PDPs from being paid. And may I just finish? There's nothing conditional about the resolution of 31 March, number one. And number two, it is admitted in the pleadings that on the 31st of March, it was resolved and it wasn't conditional. And there is a limit to how many new versions that we can put up.
Well, we apologize for that poor sound quality, especially coming from the judge, where we're not able to really hear her questions properly. But that as the court case of former SAA Chair Dudu Myeni appearing on questions on whether she has been a delinquent director. They're saying that questioned about her decisions in terms of governance and procurement decisions while she was the chairperson at SAA. It's a continuing trial, and the rest of it will be shown here on the SABC News channel. That's it for the agenda, though. For now, next up is On Point.